Welcome to Connected Conversations. I am Elena Petrova, founder and CEO of Adastra Inc. Tune in as we share inspiring stories, connect with local heroes, and discover solutions that uplift us. Welcome to Connected Conversations with Elena Petrova. And today I have a guest, Scott Mirsky. Guys, one of the things I want to say that Scott is a lawyer. He is a legal counsel. Please make sure that anything that we discuss today do not take it as a legal advice, because each situation is different. And if you do need a legal advice, then of course we will provide details, contact information for Scott in the comments and the footnotes of this podcast, and you will be able to contact Scott for anything that you might be motivated to research after our conversation today. Scott, over to you.
Thank you.
Again, thank you so much for coming over. I know how busy you are.
I appreciate you inviting me. Thank you.
So tell us a little bit about what are you working on? Tell us a little bit about your firm.
Sure.
And for our listeners, the reason why I invited Scott is because we have a long-standing relationship. I have a lot of trust to Scott. He not just a lawyer who is doing his job for the right course, as I always say, but he also involves himself a lot into the communities and serves to our communities. A few things that I want to mention: that for the language access industry, we have ASTM standards, and the current ASTM standards were drafted with the help of Scott Mirsky. He also does a lot of work for the Association of Language Companies for multiple years now. Again, thank you, Scott. And for my business, you helped us so much for the 15 years now on both negotiation, litigation, and quite a few settlements right now.
Yes.
So again, thank you, Scott, for everything that you have done for all our communities.
Thank you. Well, thank you, first of all, again, for inviting me, Lena. I value our relationship and friendship and all the times that we've spent together. But a little bit about me. I've been an attorney for almost 30 years. I primarily focus in the employment area, helping companies deal with navigating employment issues, dealing, from wage and hour issues to independent contractor issues to, whatever issues businesses are facing. I do from time to time also represent employees or high-level executives, even physicians, in helping them navigate difficult employment situations, hopefully trying to get to a win-win situation where everyone can kind of move forward in difficult times. My firm does a lot of other things. We do a lot of real estate. We do other types of litigation. We do some tax work. We do we do a lot of construction-related litigation and contract negotiations, and we're based in Montgomery County, so we also do some zoning as well. So we do a wide variety of things, but my focus primarily is on the employment side, representing management, helping them stay abreast of all of the changing laws, both locally and throughout the country.
And one of the reasons why, again, we are here today is due to the experience that, Scott, you have on the labor law.
Yes.
We live in such an uncertainty today. And just the other day, a couple of weeks ago, I was sitting in the restaurant here in Washington, D.C., having a dinner with the friend, and she works for federal government. And it's so, for me, heartbreaking to see where from the community of federal government employees I hear, okay, I'm going to come to the office, but I'm not going to bring the lunch with me. because you're not going to make me spend a penny in DC. Then, of course, I am looking at the people who are serving in the restaurant. The majority of them are not from DC. They're driving from Virginia, Maryland. Then I'm talking another friend of mine who is saying, well, what is happening to the government employee communities? The corporate sector has been going through this for years. We can lose the job, we go through the cuts. Well, welcome to our world. And not to mention the immigration reform, and there is a lot of tension there. I see all of this, and it's almost like one community goes against another community, and we have so much misunderstanding. Scott, what can we do today with our conversation to bring the information? Because to me, once people have the information, maybe, just maybe within our conversation, we can bring people together a little bit, right? Because this whole podcast is about how can leaders from different communities learn from each other to bring positive impact to the people that they serve. And you specialize in labor law for multiple years. So let's talk about today about, again, so what do we have? We have employers, we have independent contractors, and then we have employees. And one way or another, the current administration and all the changes that they bring, it affects everybody.
Correct.
Right? And so from what I see is the current administration changes mostly around deregulation and employer-driven sort of segment of changes. And tell us more about what you see.
Sure. Well, I would agree with you. Well, first of all, these are very challenging times for everyone, whatever side of the coin you're in, employer, employee, independent contractor. And obviously, if someone's going through a life-changing event like losing their job, that's obviously very significant. But from the employer side, yes, there's deregulation. I would say that the current administration is more about pro-business and less regulation. The view is that regulation sort of stifles business and business opportunities. What is happening though is that everything is happening at a very rapid pace, and rapid pace does not necessarily lend itself well in the employment sector, or really in the legal sector as a whole. Traditionally speaking, when new laws are going to be passed, or new regulations, or new courses of action, they're typically studied, analyzed. There's town halls, there's discussion groups, and employers have a lot of time to prepare and consider and implement, and maybe even speak to their employees and get input and decide what the best way is to move forward. In the current situation, when things are happening so rapidly, there isn't necessarily that opportunity, or unfortunately, to have as much open dialogue and planning, which is really, I think, the most important thing that we typically tell our employers, that you need to plan, and we're able to forecast what's going to happen in 3-6 months as far as regulations. When a regulation or an executive order comes out and it requires a quick pivot from where you are, that creates havoc in the workplace, both for the employer and the employee, and creates a lot of uncertainty for everyone. So I mean, yes, there's uncertainty for the employee, but just to step back and think about the employer is also grappling with this new deregulation or new executive order at the same time as everyone else. So while deregulation in itself might be a pro-business concept, it doesn't necessarily mean that there's going to be an immediate benefit because the employer may need to figure out how they're going to manage that. And that's really, I think, where we are right now, is trying to manage, the individuals who are working for our companies.
And I agree with you, because I belong to the category of employers.
Right.
I showed you just before we started that I received an email due to executive order, and particularly the efficiency-related executive orders,
Right.
that there are quite a few contracts have been canceled.
Right.
And then, of course, I'm sure I'm not the only one, because we are here in Washington, D.C.
Right.
It's an area of government contracting. So then, of course, we also, just like you said, need to pivot and communicate to both independent contractors that collaborate with us and employees. So there is a challenge here. In your environment, in your law firm, you guys work, like you said, in different areas,
Right.
healthcare, probably like language access,
Language.
and so many other businesses. Is there anything that is common right now, any common trends that you're seeing that employers are experiencing?
Yeah, I think that there's a sense, I think the common thread is sort of the fear of the unknown, and sort of balancing that. I think that employers, for the most part, want to do the right thing, both from a legal perspective and for their employees. And I think the common theme is that everyone is being cautious. I think in every decision, whether it's to lease a new office space, whether it's to buy a new business, whether it's to sell a business, whether it's to hire or let go employees, everyone is nervous about how to best do that. I think that's the negative. I think from a positive sign, I still think that business is moving forward. I don't think that it's. I think that maybe some big decisions like a merger or acquisition are possibly being put on the back burner, but the day-to-day operations, like your business, providing language services, those things are still happening, right? I mean, there may be a lot of other moving pieces behind the scenes that either your workforce or your customers aren't aware of, but the day-to-day mission of businesses, at least in the DMV area, I think is still moving strong. And I think that it's just that I don't think that businesses are definitely going to think twice about expanding or making big purchases. But the day-to-day operations, I haven't noticed a tremendous amount of differences.
Do you see a change in terms of reaching to the settlement through negotiation versus litigation, arbitration? Is there anything change in that field?
In the last couple months, I think that we still are seeing probably the same amount of litigation. I don't think that it's impacted things very much. I'll say that one area where it may be impactful is that there's been a lot of litigation about the executive orders that have been issued, hundreds. And I do think that sort of a ripple effect may be that I think the judges are getting a little bit inundated with these lawsuits, and I'll call normal or traditional lawsuits that have either been filed or are pending, maybe taking a back burner. For example, we're waiting for a decision on a motion, and I was like thinking like, I wonder what this judge is. Maybe they're dealing with a very meaty issue regarding national security or one of the executive orders. And when I did some research, there have been some cases that are filed that this judge is handling, and I'm probably thinking, rightfully so, that my case that's dealing with a Fair Labor Standards Act violation may not be may not be top of mind, understandably. So I think that this is what I'll call sort of the ripple effect. Like, yes, it's not a direct linkage, but I think it affects everything. It affects what legislators are focused on. It's shifting everyone's focus, and unfortunately, I think it's shifting people away from the some other things that are of very important significance as well. And so I think that employers have to be mindful that there's a shift in where everyone's focus is, and that may slow things down both in the litigation world and may encourage parties to settle. I mean, when litigation slows down, sometimes parties do decide that it just makes more sense to try and get a resolution. However, I will also tell you that if you don't have a court date, sometimes it's hard to get people to come to the table. The best thing to get two parties to a settlement table is tomorrow is your court date, and without a court date, things can drag on. So I do worry about the overall efficiency of justice when there's so many other things going on right now.
So again, back to the point that uncertainty is kind of like a big cloud around us right now.
Unfortunately, I would agree with you. I think that there is an uncertainty. I think can sometimes stifle, at least in the short term, entrepreneurialism and other things. So again, I think that that's normal whenever there's change. I mean, change isn't necessarily bad, but it's hard to wrap your arms around this amount of change at one time. I think it's difficult for an employer to deal with. Like I said, usually the law moves slow. And, I would say that for many, many years, especially when I was a younger attorney, I mean, the law would move very, very slow. There would be very slow changes. And now we're just sort of in rapid fire mode, that the law is changing rapidly, and it does present a problem with coming up with ways to deal with it effectively.
And so let's take a look. So now we talked about the employer.
Right.
Now let's take a look at the independent. Well, let's talk about employee first, and then we'll move to the independent contractor. With the employee relationship, employer-employee, because I'm sure that was affected in one way or another, because employer probably does not have as much freedom in terms of bringing people from overseas, because H-1B1 is limited or maybe under ban, depending on the country, because there are some countries are banned right now. We're also looking at some of the protection was loosened, so to speak, if not taken away. We are talking about sexual harassment, LGBTQ community.
Right.
So what are you seeing in that area
Sure.
in terms of labor law and overall
Sure. Well,
relationship?
Right. And I would say that, like I said, back to this ripple effect and your example, like at a restaurant in D.C., that if all the government contractors and government workers aren't around, then there may not be people at that restaurant or bar, and there may not be any money for those employees and for that business to stay open. So it is a problem. I think that it is important to recognize that even with all of the executive orders, maybe this is too big of a statement, but the laws haven't changed. Enforcement of the laws may have changed. So I understand that employees could be nervous about where they stand. However, many of the protections that employees have are statutory and are not necessarily directly impacted. Well, they're somewhat impacted by the executive order, but not fully impacted. And so, in other words, you still cannot intentionally discriminate against a worker. So if that is the case, that worker still has protections, even under federal law. And I would also back up that there's also state law and sometimes county law that also protects individuals. And I think one thing that we're sort of striving in the legal community to promote is don't get caught up so much in the news soundbite that you hear, okay? Because you really need to peel the onion back to understand what an executive order is or is not doing. And to say that, the executive order, making a blanket statement says that, there is no, you can discriminate now in the U.S. I mean, that would be a misstatement of an executive order. There may be, but the sound bites that are coming out sound like that's what's happening. And unfortunately, what is happening in the workplace and in society is people are taking those sound bites and sort of thinking that is the law. So I would say to employees and employers, but really employees as well, is to educate themselves on what an executive order really is saying, both for themselves and for their coworkers. And they may even need to educate their employer and say, no, that's not what is happening here. And so I do think that education is important, and to sort of read as much as you can from a non-biased source on legal topics. There's great articles that different law firms write, that different legal periodicals write, that sort of say, this is what this executive order does and does not do. And I think it's important for employees who are nervous about losing their rights to fully understand the scope of the regulation of the executive order, and not necessarily to not take advantage, and to not allow other coworkers or employers to take advantage of them because of a misunderstanding. And again, this goes back to the rapid situation, because things are happening so rapidly that's also where there can be miscommunication.
That's absolutely where it's going to be miscommunication.
Right.
And we are being bombarded with this new information every week. We have several new executive orders.
Right.
I can imagine how difficult it is for people to process these executive orders. We have people within the federal government, their job is to read those executive orders and interpret them and create guidelines.
Right.
So for us, citizens like me, it could be very misleading, right? What I would like to clarify here, though, because you are a lawyer, and you can tell us that no matter what executive order is coming out, none of them can change a law, or none of them can change a statute, because the law of the land cannot be changed by executive order. Is it correct?
Yes, but the enforcement of the
law can be different.
And the focus of what administration wants to focus on can be.
That's correct.
And
yes.
I'll sort of give you an example with some of the regulations that are coming out with there's been some change in the employment discrimination laws. And
could you give us please
okay,
an
so
example?
the discrimination laws, there's this theory called disparate there's disparate treatment and disparate impact in employment discrimination. So disparate treatment is when you intentionally say, I'm not going to hire someone because of their skin color. That hasn't been touched, but there is a recent executive order that's dealing with disparate impact, and that's where you have a policy or a procedure that might harm a protected group. And the current administration has done an executive order that type of discrimination should no longer be actionable in their mind, or that it's unconstitutional. So the EEOC, which is the agency that oversees employment discrimination issues has been directed not to kind of enforce that portion of the law, which I will say was established by the Supreme Court by interpreting the federal law. But that doesn't mean that you can't hire a private lawyer. Well, you still would need to file with the EEOC because there's some administrative protocols. But you could still bring those claims in court eventually, in federal court. They're not evaporated yet. There may not be enforcement mechanisms through the EEOC, but there are still other ways to enforce that portion of the law. Plus, there's state and local laws which are unaffected at the moment, based upon where we stand. Now that could change based upon different actions taken by legislators in different jurisdictions. But for right now, yes, you'd have a harder time bringing a disparate impact claim through the EEOC. In fact, if they were pursuing it as of right now, they probably would stop pursuing it, or they've been directed to stop pursuing it. They would probably issue a right to sue letter, and then the person could hire a private attorney and still go to court and try and enforce the law of the land. But the government isn't going to be spending their resources on fighting on that side of the law, which I will say the Supreme Court decision that type of theory is based on is back from the 1970s. So it's not something new. Of course, there'll be legal challenges to it as well, but it doesn't mean that an employer now can discriminate. It's just sort of the focus and some of the mechanisms that may have been available to an aggrieved employee may not be available. The road may be harder to bring those claims. I mean, it may be.
It will be, yeah, it will be. And then I suppose that's where the power of community comes to play. Because again, this podcast is about communities,
yes,
community leaders, and how they can bring the positive impact.
Yes.
As correct me if I'm wrong, U.S. and Europe have different law systems.
Right.
U.S. law system is based on the precedent case, right? So that's what I'm thinking, that in this particular climate, if communities will go to court and will continue bringing the cases,
yep,
we will be continue setting up precedents.
Yep. I think that we standing together as a community or an association that shares the same values that you have is very important. Most of the lawsuits that are being filed, from against the executive orders, are being filed in large with help, with nonprofit associations who are supporting, a particular cause. So if you feel passionate about something, you should, contact the various agencies that hold the values that are important to you, and join in, at least vocally. You can also feel free to vocalize your opinions to your federal legislators, and let them know that you are unhappy with how, if you are unhappy, let them know that where you stand on these issues. Legislation can certainly is an option. I also think that it's important to look at to your state and county and local leaders, because like I said, I do think that there may be more willingness to try and enforce. If the federal government wants to take a different purview or a different course of action, that doesn't necessarily mean that the state has to take the same. And there's also state administrative agencies that look into employment discrimination, very similar to the EEOC. So if the EEOC isn't going to be helpful to you, there may be the Maryland Commission on Human Rights or Human Relations. I might not have the exact name right, but that you can file a state claim as well. So just if one path is blocked, don't give up. there may be another path, and you might need to talk to a lawyer or someone at a nonprofit to understand those paths because they're very nuanced, right? But all because one door is blocked and one pathway is blocked, there may still be a pathway to the right or left. And I would just say sometimes we go down with blinders, especially with the media, but don't try and see the big picture, try and reach out, try and read, try and get as much knowledge as you can, because there's people thinking of creative ways to sort of circumvent an obstruction or what they view to be an obstruction.
Perfect. Thank you, Scott. Now let's take a look at the subcontractors category and relationship between subcontractors and employers. And so what changed there? Because
Sure.
between these two administrations,
Yeah.
things really shifted in that
Yes.
in that field.
So the current administration is very in favor of independent contractor relationships, and just as a way to back up, an independent contractor is typically someone who operates their own business essentially, and they are they're like a small business, I guess, or a small operator. Some are sole proprietors, some are small LLCs, but these are people that don't want to be constrained to be an employee. They may work for multiple companies. They kind of control their own schedule. So the administration is very pro this type of workforce. The prior administration was more inclined to almost get rid of an independent contractor if they could have had their way. They were more of the mindset that pretty much everyone should, be an employee. And there's a history because of that. I mean, the reason is that an employee, they feel, has more protections, has unemployment insurance, may have health care, has a lot of other things that that an independent contractor may not have. But most independent contractors that I've spoken with are happy being independent contractors. Now, there are some exceptions, because independent contractor, and I think where society unfortunately gets us a little bit blurry, is not all independent contractors are the same, right? Some are more gig workers, and they may be on the lower pay of the scale system, and maybe there's an argument that they have been misclassified. And then there's what I'll call higher level independent contractors, knowledge-based independent contractors, who are much more independent, have their own business. So under the new administration, if you're an independent contractor, you should have you should be in favor of the current administration and their efforts to allow you to continue to be an independent contractor, which allows you to, as long as you have control over your business and you have profit and loss and you take responsibility for that, this administration will be favorable to you. What we've usually seen between the two administrations is sort of like a pendulum. Like when one administration comes in, they kind of shift more towards wanting an employee model or solely employee model, and then back to the Trump to the current administration, and in the Trump's prior administration, they were pro independent contractors. So I like to think of it as a pendulum, and obviously, in 4 years the pendulum will shift again. So I don't think anyone can do any planning more than at least a 4-year lookout period.
Right. I remember with the previous Biden administration, we were advising contractors to register LLCs.
Yes.
Some of them didn't want to do it because they were saying it's too expensive.
Yes.
We were explaining that, again, there are tax benefits to it. Again, if you want to do some tax deductions. Is there any changes right now with the current administration?
Well, I would say that all of those things are still good guidance, because you do need to remember, there is something that I should have mentioned, and I'm glad that you brought this up or followed up, Elena, is that, again, with the current administration, we're talking about primarily federal regulations and federal issues.
But not state.
But
because
not state.
States are still having.
Right. So
yeah.
the states, especially if there's a state that, you know, is more pro employee model, you would still, my suggestion would still be to do all of those things, right? And if you're a large business where you're in multiple states, most likely you're probably in at least one state that is pro employee model, and so you still should be doing that. I just think you're not going to have as much disturbance from the federal government side, but I think the state side is still out there. And I think that's also where another example of where there can be confusion, right? You hear that that the federal government may be doing X, Y, and Z, but it doesn't necessarily impact what you have to do in California, because California law may say, no, we don't want independent contractors. So again, it's sort of that thing that you can't look at things narrow-mindedly and just look at you have to look at it in a totality and not in a box. And that's, again, goes back to education and understanding that you need to look at, you know, what state are you in? Start there. You can start at the federal government and then work your way down to the state level, but don't forget about whatever rules or regulations or rights that you might have as an employee or an independent contractor in a given state. And again, it also comes down to enforcement, right? So is this particular state likely to enforce? You know, and there are some ways to know, but if you're in a state that is pushing for an employee business model and is kind of anti-independent contractor, then that would be a state that you would be that could be more likely targeted. And that's why I will touch on that independent contractors, again, if you have, that is why you may feel that there's been a lot of businesses may have starting to put a lot of requirements on you to do business with them. And again, that is solely because they want to make it, it should be a business-to-business transaction, right? So while, yeah, there's a contract you have to sign, and that's probably annoying, that's what businesses do, right? And you want to be an entrepreneur, you want to be a small business, and you sort of need to act like one. You need to get your LLC, you need to pay taxes, you need to get insurance, or whatever else a business needs to do. With independence comes responsibility. And those things are important. I mean, there's a host of reasons to do that, but obviously and that's why if you are an independent contractor and you're being asked to sort of jump through a million hurdles to get a job, that's why. And the more that you can get over those hurdles earlier on your own, the more attractive you'd be to probably someone like Lena, who works with independent contractors, because you're already ahead of the game, right? And you've made yourself look more attractive than maybe a different independent contractor who hasn't taken those steps.
And then let's take a look at, let's start moving towards the government space. We are based in Washington,
Yes.
D.C. We can't avoid this.
Yes.
With the government space, though, with the previous Biden administration, there was a lot of weight put on, if you remember, there were a lot of settlements that we were working on, and even with your firm, on related to the, what was that, the, oh my gosh, was the salary wage form.
The Davis.
Do you remember the
Oh, yes,
minimum
service
wage?
contract.
Yes, the minimum wage form that we had to
Right.
fill out for each bid, for each proposal,
Right.
and then we would get audited to make sure that we are meeting all those requirements. And I remember at some point that even if the government bid did not have that requirement within the proposal or the contract, we still were the guidelines were there, even if they were not on the paper. We had to follow that, and if we were to get audited by Department of Labor, and if they find us not compliant with that, there would be repercussions to it.
Right.
From what I was reading in preparation for our conversation today, it looks like it was that regulation was moved by the current administration, and then also after there were changes in after hours on the federal level.
Yeah, I think that what we're noticing is, again, back to deregulation and all of the protocols and rules. I do think the minimum wage rates are still probably going to stay in, at least in place, but some of the regulation hurdles that independent contractors are going to be looked at by the most recent executive order, one of the more recent executive orders that you're referring to sort of make it easier for people to contract with the government and to put down some of the barriers, which is that's probably good news for a government contractor, that we're going to make things more efficient and less of a headache moving forward in the government contracting space. I don't think that, I think that the executive order has given some time for the government contracting people to sort of figure out exactly what that will look like. But it was clear that the current administration wants to reduce the hurdles and the steps and the bureaucracy associated with getting or being awarded a government contract. So I mean that I think is clear that's an important goal. Again, how do we get there? I think that may be a shakier road. Again, I think a lot of things that are proposed in the law are maybe really good ideas in concept, but how you get to the end result, as I say, like the devil's in the details, right? So, and I don't think we don't know yet. And so again, that's another thing that we need to kind of keep an eye on, and just another one of those things that we need to stay abreast of.
Now let's go. So basically, with the government contracting, in your opinion,
Yes.
for subcontractors as well as employees, we might be seeing positive changes.
Yeah, I think that is true. I think that we are going, at least at the federal level, a movement to allow people to hire independent contractors. I think,
With the exception of any executive order that is related to efficiency.
yes, and I guess if you're hiring someone, in some other capacity that may be violating some sort of executive order, but yes, I mean, correct. I mean, I think it's a generalization, but there's always an exception, and I think that for the most part, the government wants people to have the fewest obstacles in doing business, and I think that they feel that allowing independent contractors is a very positive and entrepreneurial way that companies do business in the U.S., and to force people to hire everyone as employees is counterproductive, and I think also underlying this issue is sort of the unions. I mean, the unions want people to be more, more. They would prefer more people to be employees and fall under the union's jurisdiction. Another thing that the current administration is trying to platform is they don't want employees to be required to join a union or pay to pay union dues as a requirement to work for a particular employer. Some states say that that's okay, and the current administration does not like that idea that people should be free to work as an employee without having to pay union dues if they want to. If they don't want to join the union, they shouldn't be required to do so. Now, obviously, the unions wouldn't be happy with that, and so. But again, it's all about just sort of with the idea of there being less regulation and people are free to sort of do as they see fit.
Right. So again, lots of uncertainty here. What are the future trends that you are seeing? That I'm hoping that we can see some future trends that are building up in this type of uncertainty. Because in my opinion, when you see future trends, you know what to get prepared for.
Yeah. Well, I think that there's a couple things. I mean, I think that we can see that where that the administration wants there to be entrepreneurialism, and I think we can also see that there was in the last administration a lot of efforts in the federal government at least, as well as the states, to sort of block non-compete agreements, for example. And now it's pretty clear that under the current administration, non-compete agreements are probably going to be acceptable, with the main caveat: check your state, because every state.
You are saying that non-competes are coming back?
Well, they never really. Well, it's confusing. At the federal level, maybe. At the federal level, there was a law that Biden, or regulation that Biden was trying to get through that would make all non-competes illegal.
Yes.
And then there was injunctions and there was hearings, and that never really went into effect. Mm-hmm. Okay, so there was never a federal ban. There was a sort of an effort for there to be a federal ban. But with this new administration, there's no effort to have a federal ban on non-competes. However, each state has its own rules. And I will tell you that in the last 10 or 15 years, so many states have either abolished or restricted the use of non-competes that we're not at a national ban, but we're at a very checkered. Many states have different types of bans, either based upon the professions that a non-compete can be issued for, or a wage requirement that you have to pay people a certain amount of wages in order to have a non-compete. So again, that sort of goes back to this thing, well, the federal government may say it's okay, but what about my state? So you can't, and again, if you're an employee, you need to look at the state where you are. If you're an employer, or even an independent contractor, you need to look at what states are you doing business in, where are you operating, and it's not a clear cut, one size fits all solution in any of this, but especially in the non-compete world. I would say that non-competes are still under attack and are really losing favor, both in society and in the law. 15 years ago, 20 years ago, if you would have said, I want to enforce a non-compete, especially in Maryland, I would say, go for it, Lena. We're going to win, right? Now, no, I would say we may not win, and we may lose bad. I mean, it depends on the state and the situation and who is being covered by it. But it's not as clear cut. It used to be very, very clear cut. And this was an example. I was saying that the law used to move slow, and now it's moving fast. But we also, as far as current trends, I think where the other thing that people need to be prepared for and that we're dealing with, putting aside the current administration, is the remote workforce. I mean, we talked about it a lot during COVID, but it's still there. And I think that creates, I think if you as an employer can figure out how to navigate the remote workforce, both legally and operationally, that will be a very you will have a very strong business. I think where we're seeing problems or issues is where, people want to have, if you're going to have remote employees, you need to have many things in place to deal with that. So I think that the future is bright, but you need to figure out what your culture is, and then how you are going to deal with that if you're going to be in a remote workforce. Because I think what we're really seeing is that we have a remote workforce and we have some freedom of mobility where employees can jump from one job to another very easily now without restriction. So how do you manage that as an employer? And how do you keep your employees happy? Because one thing to remember is the law, in many cases, sets the minimum standard, right? It may say, and a lot of states are going to having mandatory paid leave, where you have to pay paid leave, right? And maybe they require 1 hour for every 30 hours that the person works. Well, you're not, that's the minimum. I mean, if you want to give more and be a generous employer, you can, right? And so you need to sort of keep up with the Joneses. Like if your competitor is giving, 4 weeks paid vacation for paternity, for family leave, we'll call it, you might need to do the same, right? The law is sometimes guide rails, and that isn't what you necessarily need to do to be a good to keep your employees happy, especially in this world of mobility and remote, because now employees are free to, they don't need to come to your office, right? So, and likewise, they don't need to go to your competitor's office to work, right? So now they can go anywhere. So they're going to be shopping, or people rightfully so, for the best benefit package. So my suggestion is, always is to treat employees well, and you'll have less problems.
That's very true. Let's talk about the remote environment, because I think it's
Yep.
kind of like very hot subject right now,
Very.
particularly with the government employees going back to the office
Yes.
and the comparisons with the corporate. What are you seeing? Because again, you work with so many different industries.
Right.
First of all, what is the trend in the remote environment?
Right.
Do you see people going back to the office here in US? I know in Europe and in Asia, mostly all employees are requesting people to come to the office. What is happening here?
Yeah, I think that most people, I feel like most companies have sort of settled in on where they are on that policy. Either they've already sort of made the decision if they're going to be a remote workforce, a hybrid workforce, or an in-office situation. I think where I mean, obviously, if you're going back into in-office, I think it probably is the least headache for the employer, because it's clear. It's just then you're back to the sort of the traditional model. Now your employees may not be happy, but you're back to a more normal model, and you know what laws you need to comply with. When you're in the remote workforce, you have to comply with whatever jurisdiction your employees are working remotely from, which could be many states or even abroad.
So, yeah, because then again, from the standpoint of compliance, you're probably dealing with multiple states.
You are. And so that becomes a headache, but yet you might need to do that to balance, to get the best candidate, right? And to keep your workforce happy. Plus, you need to have mechanisms in place for security and efficiency. And how are you monitoring these employees, right? It's one thing when you could just kind of go down the hall and peek your head in. Is Joe there? Does it look like Joe's working on his computer, right? But now Joe's working in Nevada. I don't really know what Joe's doing, and his workday is slightly different because it's a 3-hour time difference, right? And we've seen a lot of situations where employees have multiple jobs because they're remote, right? So they can still kind of do their side hustle while they're working for you. And so I think that if you want to be a remote employer, you need to think about all of these things. How are you going to measure productivity? I think it can be done. I think the hardest, in my opinion, and the clients that I think have the most struggle are sort of the hybrid, because it's like you kind of don't really have an identity. You know, what are you? Are you remote or I think that's the hybrid is really, really complicated, I think, to manage as a culture. You know, from a legal standpoint, it might be manageable, but I think how do you manage a hybrid workforce where some people are coming in, some people aren't, some people are coming in 2 days a week, some people are coming in 5 days a week. I think that it's hard to build a culture, right? And this is about building a community. And I think the workplace is a community, right? And I think that if you want to have a remote workforce, you need to work and this isn't really legal advice, this is just my personal opinion. You need to work on building that community, right? And you might have to do events. You might have to do things in the evening, you know, where everyone comes on and does like a virtual happy hour. You have to do in-person events where you bring all your workforce together, right? You need to do those things because you need to create that culture that you once had in the office. So you need to commit to that. And again, if you know you're remote, then you can commit to that. If you're in office, then you can commit to that. If you're hybrid, it's hard to know what you're committing to. And I think that's where, in my opinion, the culture breaks down. I think it's more likely that you have, you know, discrimination issues because why does John get to work 2 days from home and Sally has to come in 3 days? And how do you manage that? And I think that's a lot harder in a hybrid environment. So I've kind of, I think you need to figure out your identity first, and then we can build the laws and the culture around that. But you need to have a plan, and if you don't, you'll know because your employees will leave, and you'll know quickly that you don't have the culture that you thought you had.
So looking at trends, so we have a trend of non-competes,
right,
and then we have a trend of remote environment,
right,
obviously. So with the remote environment, and we are saying that non-compete, we need to look at state by state. With the remote environment, I'm curious if there are any particular laws on compliance that go state by state when it's related to remote environment.
Well, with non-competes or in general?
Oh, no, on the remote environment.
In the remote environment, yeah, it's a very good question, and it's a debate amongst us professionals. When is someone working in a particular state versus another state? Clearly, I've heard my colleagues say that if someone's in a state for 30 or more days, they're probably deemed working in that state. I'm a little more, my view, and it's not really a legal opinion, but I like to think of it as if they're spending 6 months or more in that state. I feel like if they're going to, Dewey Beach for the summer and they're spending 2 months there, are they technically working in Delaware? I think that's a gray area. If they move down there and spending 6 months of the year in Dewey, then I think they're definitely covered by the Delaware laws. I think there is not, most laws, there are some, but most laws don't define what the amount of quantity you have to spend in the state to fall under the jurisdiction. They've kind of left it up for interpretation. There are some laws in the District of Columbia that do speak to about if you work X amount of days in the district, then you're covered by this particular law. But that's an exception. Most laws that say, you have to pay minimum wage in a particular state don't really discuss exactly, what that looks like. Now, I will tell you, if you had, a restaurant and they had 2 physical locations, and sometimes you were at the Maryland location and sometimes you were in the Virginia location, yes, if they're working at your physical location in those states, you would have to pay them the minimum wage of those states. I just think that if you're visiting a particular state and you're opening up your laptop, it gets blurry whether or not, and I think that is an example of where the law typically lags behind. And we need clarification, but we don't have it yet. And that's usually, and that's sort of I think that wraps things up nicely with the dichotomy of what we have now in this rapid fire environment, right, where we have rapid, we need to get resolution to all of these things, and we're dealing with that. And then we have things like the remote workforce that we've been dealing with for like 3 years, and we still really haven't been able to wrap our arms around it, because we don't know how to deal with it, and we don't have a clear, there's not a lot of clear direction, and that's something that employers are struggling with. But I will tell you, you have to be careful, because if you have people in different states, you need to make sure you're complying with those laws. If you have someone in Canada, in Quebec, for example, they have laws regarding whether or not you can terminate someone for calls, and you have to give certain type of notice if you terminate someone. Well, if you have someone working in Quebec, 9 months out of the year, you're probably required. You are. I mean, you're going to be under Quebec law, and you're going to have to deal with that situation. So, and further complicated is, do you know where all of your employees are? I mean, you don't know.
I know, and that's and trust me, I'm familiar with the Quebec law, because we have an office there.
Right.
It's challenging, and now the challenge is that no, I actually don't know where my employees are.
Right.
Most of the time, and that's another question is to you. Can employer restrict? Well, of course, with the independent contractors, everybody is free to do whatever they want,
Right.
and that's the relationship you have. As long as the work is done, the work is done. We
Right.
work on projects. Now, with employees, though, if employee and employer have a relationship that we work for this company together, this is the company, can employer restrict employee to work for other companies in a remote environment?
Like most things in the law, it depends. It depends in what state, because some states you can't restrict them from moonlighting. Now, you can still have policies.
Yeah, that's that moonlighting. That's the term.
Right. Now, you can still have policies that what we're recommending to people is that you beef up your confidentiality provisions and your security protocols, so at least there isn't like a transmission of data that could be harmful. But it depends which state and which law you're falling under, and so depends. You may not be able to restrict, but you can certainly restrict, that they can't use your confidential information, working for a competitor. They can't take your customer list and things like that. But that would also bring me to the question is, why do they have maybe they shouldn't have your whole customer list, right? Some of this is back to common sense, right? Like, if you can, you have to protect what's important to you, and not kind of look at it after the fact. But yeah, I mean, in like DC, there's strict rules about you can't restrict an employee from moonlighting, and so you have to be careful what jurisdiction you're in. But every jurisdiction will allow you to protect your confidential information. So we've been striving to kind of beef up those type of provisions, and not, try not to be on the restrictive side of what the employee can do in their time. Now, I do think that you can say, we expect you to work for us during, these are your hours, like you're supposed to be at your computer working for us from 9 to 5. If we find out that you're not working for us 9 to 5, then we're going to terminate you, right? I mean, you can do that, and I think you would be well within your rights. However, you might get pushback. What if someone says, well, can I do 8 to 4? Can I do 7 to 3? And depending upon what industry you're in, that may or may not work, right? I need to take, you want to be flexible. Can I take a 2-hour lunch? I have to pick up my kid from 1 to 3. Can I do that and then start up again? And again, I think that comes back to, like, do you want to keep the talent pool happy? right? And that goes back to the whole thing of what kind of community are you trying to build as an employer? What kind of place you want your employees to feel comfortable coming to work, whether that's in person or remote, and you want to build an environment where you allow them to do certain things but not take advantage of you. And where you draw that line is probably something that business leaders grapple with every day, right? Because I do think when you do something nice, it does sometimes, you worry that someone may take advantage of you as an employer. But
And it goes both ways, right? So we always say that it's all about trust.
it is
how
all
you
about
build
trust.
and then the law is here to put the boundaries in place, I suppose.
That's right. And as an employer, I mean, both the employee and the employer, absent some extenuating circumstances, in most states, if they don't have a contract, have the right to end the employment relationship. So if there is if you don't like what your employer is doing, you should feel comfortable. You're allowed to leave, and for the most part, and the employer is free to let you go as long as it's not for a discriminatory reason or whistleblowing or retaliation. If and sometimes that has to be the resolution. Sometimes it's even mutual between you and the employee. And the best situations I've seen is when an employee leaves and they go to a competitor or a related business, and you guys are still able to work together as you like collaborate on new projects. I have plenty of colleagues that work at old firms that I used to work at that we collaborate with. They're still friends. It's sort of like don't burn any bridges, right? Both from the employee and the employer and the independent contractor side. I would say don't burn any bridges, because you never know how that's going to come back to help you. And I think that kind of goes back to the collaboration thing, that as you move from job to job as an employee and independent contractor, you're really widening your net, of people that and the people that you have experience with, and you can help bridge those gaps. And maybe your competitor, where you go, is weaker in one area than the other, and maybe there's collaboration between two companies where there never was collaboration before. So instead of thinking about, I don't want this person to be competing against me at the new place, maybe flip it on its head and say, I wonder if there's anything that I can do to work with them at this new place and actually increase my bottom line, get more work for me, and help them, because we're not really, we do stuff better than, we can help in one area and they can help in another area. I think the best way to make community and make the employee, employer, independent contractor better in society is to always look at things as a win-win. If you can put things as a win-win, then everyone is happy. And I think that goes back to what you were saying, being a good employer, right? And a good employee. Win-win, win-win, everyone's happy. And it's usually when one person's winning and one person's losing that the relationship is stifled. So I would say that, if you can change a departure relationship into a win-win, can't always do it.
And it's it's not zero sum. Maybe it's not win-win. It's sometimes not 50-50. Maybe it's 80-20.
Right.
Who knows? But the good thing, I absolutely agree with you, is that I'm all for collaboration.
Right.
Because you just never know where
That's
our processes are going to cross and how we can.
That's right. And it may not be instantaneous, right?
Right.
It might be in 5 years. Maybe it's at their next job, right?
Right.
Or maybe it's at your next company, and it may not always be linear. So I do think it's best, when I counsel employees who are leaving, you should give your 2 weeks. Are you required to give 2 weeks notice? No, but it's the right thing to do in a professional environment. Maybe that's not even enough time, right? But you should extend that courtesy to your employer, because you're leaving them obviously with a hole, and I think that's the perfect, to act. There's no law. There's not a law that requires that, but I think that's what you do as a good, person in the community. You try and, and they may not want you to work the 2 weeks, which is fine. That's fine. But you should offer that as an option. And I think that the employer typically values that sort of work, and to make your transition as smooth as possible. Because again, I think when you leave on bad terms, it becomes a negative situation, and something that ends up coming back to haunt you at the end of the day.
It's true. That's the reason why I like working with you, Scott.
Thank you.
And for everybody else, thank you for joining us today. Again, times of uncertainty, times of change, never easy. But having information at hand usually takes you through those hardships, and staying in touch with your communities. Again, thank you, Scott, for
Elena.
providing this information. Guys, do not take any of those information as a legal advice. If you do need legal advice, we will provide contact information for Scott, or reach out to your legal counsel and discuss any of the topics, have continuation of this conversation that we had today. In general, so as I'm sure a lot of our listeners were motivated and inspired by our conversation today, Scott, if there is one actionable items in sort of preparation for those trends
Sure.
that we talked today, remote environment, non-competes, because you put together those two, government contracting, anything else, again,
Sure.
protection for any of the classes that
Yes.
might be under, I would say, attack, to
Yeah.
be precise, or feel a little bit, I don't want to say a little bit, but feel uncomfortable going through multiple changes of our society.
Right.
So a lot of is going on right now. So if there is one actionable item
Right.
to look forward that you would give us an advice, or maybe a message, one message that you want our listeners to take from our conversation today, what that would be?
Well, that's a great question. I would say take a deep breath, but then get as much knowledge as you can and reflect upon that. Talk to as many people as you can to fully understand the ramifications, to make sure that you understand what is at the core of the issue, and then to start in your community or with experts, or bring experts together and try and brainstorm about alternate solutions. Because sometimes usually they're there, not sometimes, usually they're there. You just need to take some creativity. So I would say knowledge, and then put your thinking cap on, gather your friends, and then get creative, and then advocate for yourself, both in your community and with your legislators as well.
Thank you very much, and let's continue this conversation. If you do have anything to share, please leave it in the comment section, and we will see you next time. Thank you. Thank you for tuning in into Connected Conversation. We truly value your feedback and would love to hear from you. Please let us know what story you would like to hear next. Share your thoughts in the comment section. Let's keep the conversation going, and let's continue to inspire each other. Let's stay in touch. Thank you.